Okay, next up, one of the smartest people I've ever met. He's also an excellent communicator, and those skills don't usually go together. He's a lawyer, he's a man of God, he's a wonderful father. He's truly somebody I'd call a true friend, and an absolutely brilliant deal maker. Don't let him kid you to think he's only doing legal work. He's also actively doing deals. He knows how to financially structure and keep things safe all the way through. If you're lending, you should be talking to Jeff about your lending docs and so much more. If you're curious how to build tax-free wealth, you should be talking to Jeff. And today he's going to talk to us about entities, trusts, and structures so you can protect your assets and you can invest with a lot of confidence. So on your feet, and a big round of applause for Jeff Watson.
Jim, thank you. Thank you very much. All right, good morning, good morning. It is fantastic to be here. So we're gonna talk about something really technical and important today. And Mary set the stage for exactly where I needed her to do. It was such a privilege to be able to follow her. So Mary got your serotonin levels and your dopamine levels right where they need to be. And then she gave you that confidence that you're going to be able to absorb, understand, and master some very technical information that I'm privileged to share with you over the next hour. So I'm looking forward to this, and this is the only positive way I can think about having to follow a speaker like Mary. You know, like, okay, she gave you something huge and uplifting, and here I am coming with some really mind-numbing details. But here we go. All right. So we're going to talk about using trust when buying creatively, a primer on trusts. How many of you think you buy houses creatively? How many of you are buying houses creatively? Huh? Huh? That's it? Why not? Okay. All right. You're in the right place. Leon, I know you know how. I steal your stuff all the time. All right. So you hear anything good come out of my mouth about creative deals, it probably came either something from Leon, Pete Fortunato, Eddie Speed, or somebody like that, okay? Anyhow, let me get into this. A little bit about who I am. I got to ask this. How many of you have never heard me speak before? Oh, wow. Okay, well, I got to give you a little background disclosure, okay? I am not woke. I am not PC. My preferred pronouns are y'all and you'n, okay? And my mandatory adjectives are smart and good looking. All right, we good? Seriously, I've got friends on both sides of the aisle, and I'm passionate about a lot of stuff, and I'll share that some with you. I've been practicing law in the state of Ohio now for 32 years. I'm privileged to have been a part-time real estate investor now for 29 years. Still own the very first house I ever bought in January of 1994. Full-time active practicing attorney, usually representing self-directed IRA clients and other established real estate investors. And then the last thing is I'm privileged to be general counsel to some pretty interesting organizations, a company like RealFlow, National Real Estate Investors Association, Note School, and National Wealth Builders. A couple of things I've done. I've changed the law in the state of Ohio 5 times through litigation and legislation. I've influenced national housing policy 3.5 times. Let me tell you about the 0.5 real quickly. How many of you have heard of the Renters' Bill of Rights? How many of you are in support of, and a fan of rent control? Huh? Wait a second. Nobody in here likes rent control? I'm shocked. Don't you know rent control is an essential element to affordable housing? Don't you know that the government needs to be able to tell you what you can do with your hard-earned assets? I mean, that's the way government works, right? You earn it, you own it, but they tell you what to do with it, right? Hopefully you can understand my sarcasm. So I am a passionate opponent of rent control. If you don't know anything else about me, don't write down anything else about me, Jeff Watson opposes rent control. I've got members of Congress on both sides of the aisle to agree that they will not approve a single dollar of appropriations for rent control or the Renters' Bill of Rights between now and the end of this session of Congress. I've got both Democrats and Republicans telling me that. So that's the 0.5 on the 3. Now, you're going to hear from me again and again and again about rent control because this is going to be my biggest objective in the next 3 years. Because I can't just assume that once I kill it for now, it's not going to go away. No, this is a vampire that you shoot through the heart with multiple silver bullets. You then throw it in a coffin with a bunch of garlic, and then you incinerate it. Okay? All right. Boy, I got wound up. Co-authored some amendments to Dodd-Frank, Safe and TILA. That bill is going to be reintroduced next week. Congressman Andy Barr assured me face-to-face last week on that. Revolutionized short sale transactions in 2008, came up with a completely different way of doing short sales, did the documents for it. That's where I went from being a small-town lawyer in Northeast Ohio to suddenly people knew who I was. Board member of Quest Trust Company. That is a huge privilege for me, huge honor to be on the board of directors of Quest Trust. And the last little thing up here is I've got some clients that have made the Inc. 500 list as privately held, fast-growing companies. So that's a little bit about me. I got to do this because I'm a lawyer, because we're here, because we're all adults, but I got to remind you that we're all adults, and because I just got some really interesting, sad news yesterday. Another big popular investor who was working in the professional space, in the dental space especially. Paul, I'm not pointing at you, I'm just thinking because you're a dentist, and I know there's a couple other practicing dentists in the room. Another guy running in the dentist space just got popped by the SEC yesterday for running a $150 million Ponzi scheme. Yeah. So when Mary talked about due diligence, I hope you were listening. I hope you were listening. Yes, this room's got a lot of great, trustworthy people, but not everybody is your cup of tea. Please do your due diligence on everybody that you ever do business with. Okay? All right, but this presentation is designed to provide authoritative and accurate information with regard to the subject matter being covered. This is education. This is not legal advice. It is provided with the understanding that the presenter is not engaged in rendering legal, accounting, or other professional advice, including psychiatric. If legal or other professional assistance is required, the services of a competent professional must be acquired. Unfortunately, what I'm going to talk to you about today, there's not many attorneys that get this. Mary, when you took estates and trusts, you excelled at it. Most students slept through it. And that's just the way it is. There's very few lawyers like Mary that understand this stuff. It can be a fantastic thing, but can also be a problem because you got to educate them, and you don't want to have to pay them to educate them. All right. So what is a trust? What is a trust? A trust is a private contract between two or more parties. It acts like an entity, sort of, kind of, maybe, but not really. All right? So we're going to start with this. This is a test. How many of you have ever heard of the Socratic method? So the Socratic method is I'm going to give you a test and you're going to answer the questions because this is how I'm going to teach you. I'm going to teach you by seeing how many of you know the answers. So the test, a property is placed into a trust by using not a lawyer, not a trust. A property is placed into a trust by using not a trustee. A property is placed into a trust by using a deed. That piece of paper that we use to transfer title of real estate. And then, thereafter, the blank is the owner of record for that property. If you're not putting E on the end of that word, you're wrong. It is owned by the trustee in their capacity as trustee and not personally. Okay? It's not owned by the trust. That is a common misconception. It is owned by the trustee of the trust as trustee. All right, so let's get into this. I'm going to teach you a trick. I'm going to teach you what I have taught thousands of other investors to do when it comes to buying creatively. And I'm going to warn you right now, I'm going to teach you something that's not what you've heard before. I'm going to teach you something that's going to go against some of what the other gurus that are out there running around teaching it. There's a lot of people who talk about trust, but they never went to law school. They've never litigated these issues, so whatever. All right, so the buyer is the trustee of a specifically drafted acquisition and title holding trust. Who establishes the trust? Who controls the trust? You, the investor, are the grantor and trustee that forms and controls the trust. I want you to be in control. If you're a control freak, please stand up. If you're a control freak, please stand up. Stay standing. I didn't give you permission to sit down yet. So the rest of you are just what? Robots? You're not in control? What is it? All right. Everybody go ahead and have a seat. All right. So this is for control freaks. Okay? So we're going to get into this some more. All right. So the trust and the trustee. Let's go back. Did I hit one too many? Yes, I did. There we go. Okay. The trick. The buyer. When you're buying creatively, when you're making an offer to purchase a property with owner financing, subject to or a combination of both, which is my preferred method. And folks, I've just was structuring an offer on Saturday, sitting outside of a store in Spring Hill, Tennessee, talking to my colleague and go, well, why don't we take it subject to the $7 million commercial loan and get the seller to take back another $2 million? So then that way we only have to come up with $5 million to close the deal. And they're like, yeah, well, let's see if we can do that. I know we can take the institutional subject to, but let's try and get some seller carry in there as well. All right? Kevin, you know exactly what I'm talking about, don't you? Yep, I figured you did. All right. So who establishes the trust? The buyer is actually the trustee of a title holding trust. Something is skipping in my slides. Oh, well. We're going to get it. Okay, there we go. You, the investor, are the grantor and trustee that forms and operates the trust. When you're doing these deals, I want you to be the one creating the trust. I want you to be the one that selects the trustee. And in many of these instances, I want you to be the initial trustee. You can change that later on, but I want you to be the initial trustee because if you're like Leon or like me, you're having a conversation face-to-face, human to human, and I want my seller to know that they're still dealing with me, even though I'm now the trustee. They're talking to me. They'll call me. They'll text me. They'll email me. I didn't disappear on them. I didn't dip out on them. I didn't assign this deal to somebody else in exchange for a few $1,000s and run off and leave them high and dry and screwed over. By the way, you know what I think about that, don't you? Bad practices. All right. All right, somebody stepped on somebody's toes there. Okay, who owns the trust? The trust is owned by, hello, there we go. The trust is owned by the beneficiary. Now we're going to get technical and then we're going to catch a breath, okay? The trust is owned by the beneficiary. I want the beneficiary in these types of trusts to be your multiple member buy and hold LLC with its own tax ID number. It is a separate legal entity. It has its own separate legal existence, aside and apart from you. It serves as the beneficiary. But Jeff, I might flip the house. I might not hold it as a rental. I might not resell it on a wrap sub too. Great, fine. Still take title this way into a trust where the beneficiary is your buy and hold because it's much easier from a tax and accounting standpoint to move from your buy and your hold to your flipper than to go from your flipper over to your buy and hold. I'm just trying to make it easy for you and your bookkeeping and your accounting and your tax preparing. Does anybody want me to make it easy for you? Or do you want me to just make it really complicated? Easy? Complicated? How many won't raise your hand despite what I say? Because I can already feel that energy in the room. They're like, okay, I don't know if I trust this guy. He's a fast-talking lawyer. He sounds like a Yankee, too. So I don't know if I want to trust him or not. All right, I got you. We'll see how that plays out, all right? Well, in Texas, they call them liars. You know, move out over towards the panhandle. And, yeah, going to go see the liar about this document here. Okay. All right. All right. So recap this, because we're going to get into some details here, okay? There we go. You are the grantor and the trustee. You control freaks all feel really good now. You're going to create the trust. You're going to make sure it's written the way you want it to be written. You're going to be the trustee. So you're the grantor and the trustee. You've got great control. Your entity, your separate legal existence, multiple member LLC, is going to be the beneficiary. So we comply with that fundamental rule of trust law, okay? And this means that you are the boss and you can control everything, all right? So let me do it right now, right here. There's this silly notion that if I create a trust differently, like if I then engage in the unauthorized practice of law, and I have the seller create the trust, and I have them deed the house into the trust that they've created. Now I've created 2 legal documents without being a lawyer, and I had somebody else do it. Okay, that's really good. So now I've broken a couple of state laws. But now I'm going to have them create this trust, put the house into the trust. I'm going to take the beneficial interest, and that's going to let the Garn-St. Germain Act keep the bank from using the due on sale clause against me. Bull pucky. Completely wrong. You didn't read the code. Please read the code before you open your mouth and you teach this stuff. You might change what you teach. Novel concept, right, Mary? Novel concept. So we don't do that. We don't ask other people to engage in the unauthorized practice of law. We don't ask people to engage in anything with a deceptive intent. I don't care if you're running around with a hat and numbers on it and fingers on it. I don't care if you're doing whatever. We don't do that crap, all right? We do it right. Okay, let's see if we can make this. I'll catch a question at the end. Is that fair, Adam? All right, brother, I appreciate that. I'm going to try and see if I can get this thing to do more than just vibrate in my hand. There we go. Meet the team. Here we go. The team, the trustee, known by all to own and control the asset. So when we go look a house up on public record and we see that it's in a trust, we get to find out who the trustee is and who is the name of the trust. We get to know that. That's all we get to know. We know that the trustee has all of the dirty jobs. They got all the hard work. I met Mike Rowe personally last week, the voice from Deadliest Catch and the guy from Dirtiest Jobs. What an amazing, funny, live human being. Great guy. I wish I could have spent more time with him. But Mike Rowe would have you right over here. You've got all the responsibility, you've got all the duty, you've got all the work. You're right over here, okay? Then over on the other side, the beneficiary, well, that's your Gen Z, hide in the closet, have a job where you code all day, you know? You don't talk to anybody. You don't make eye contact. You go into Starbucks and pick up your mobile order. You don't make eye contact with the Uber Eats driver when they bring you your Chick-fil-A. You don't talk to anybody. You're secretive. You're quiet, okay? So that's you over here. You're private, you're secretive, and so on. But you get the enjoyment, the benefit, and the fun, all right? Those are some of the roles that are out there. Now we're going to get technical, all right? Brace yourself, folks. We're going to get technical, and then we're going to come back up and catch your breath. All right, so beneficiaries, I've already told you I want you to be this multiple member LLC. That's the partnership. By the way, folks, you don't have to take pictures of these slides. Jim and I have talked about this, and I'm going to give you guys an amazing opportunity to get a PDF of all of these slides at the end of this presentation. Okay? So yeah, I'm just going to do it. All right? And Al's looking at me like he knows that I rarely give away my slides. He has seen me preach many times and say, don't even post pictures on the internet. And I don't want you to ever post a picture on the internet. Please don't put stuff on Facebook. No, but I'm going to give you PDFs of this stuff, all right? You're not going to get the actual slides, you're just going to get a PDF. It'll be what you got. But it comes with another opportunity that Jim and I collaborated with Eddie Speed on, so we'll give it all to you that way. Okay, it's all a gift. All right, so beneficiary is your entity, your sub-SLLC if you're a flipper, Your partnership, if you're a holding, buy and hold, which is my favorite thing to do. And the Schedule C is for if it's a single member LLC that's not a sub S and it's not a partnership because it's only a single member LLC. So it's going to end up on your Schedule C. Not my favorite thing to do, that's why it's the bottom of the three. The grantor will sign once personally for the trust in creating the trust. I'll show you what that looks like in a minute. The grantor will appoint you as the trustee. You appoint yourself. You sign up and volunteer for your own job. You're good. All right? And then you fade away as the grantor. You've done your job. You've signed the documents. You've breathed the trust agreement into life. Now it's going to be, off goes the grantor hat, and on comes the trustee hat. And that's the hat you're going to wear. All right? So now the trustee will now represent the trust. The trustee does everything for the trust. If the trust collects rent, the trustee is involved with that. If the trust pays a bill, the trustee is involved with that. Now, who tells the trustee what to do? The beneficiary tells the trustee what to do. Well, Jeff, who's the beneficiary? I just told you. It's one of your entities that's got its own separate tax ID number. So do you obey yourself or not? When you talk to yourself, do you argue or do you listen? Because if you talk to yourself and you listen and you do what Mary was talking about, things are going to be good. But if you talk to yourself and you argue, that could get complicated. Okay? That could get complicated. All right. So this eliminates the investor's need to execute all the documents personally. Catch that? Let me do that again. This eliminates the need for the investor to execute all the documents personally. If you don't sign personally, can you be personally liable? That is not a trick question. The answer would be most likely not, unless you've done something subsequent. But anyhow, all right. So the key documents, we're pulling back up. We're no longer looking at the thickness of each blade of grass. We're now up at about the middle of the tree trunk, okay? So we're back up. We're not above the forest. We're down in the trees, but we're not down in the grass. You got me? So the key documents, there's 3 key documents when you're using a trust in a creative deal. 3 key documents. The trust agreement. Please make sure you invest the time and the resources and hire the right talent to give you a good trust agreement. Please. Then there is the deed to the trustee. Now you can do 2 types of deeds to trustees. I always like to have a limited or general warranty deed to trustee. I like to use a warranty deed to trustee or a limited warranty deed to trustee, and I want my deed to include in the deed itself the powers, duties, rights, and responsibility of the trustee. I want to spell it right out there so that when I put it on public record, everybody knows what the trustee can do. I want to make it really obvious. But there are some people who are lazy and their forms library doesn't have a good warranty deed to trustee, and so they use some El Cheapo document. Great, fine. We can fix that with either a memorandum or affidavit or declaration of trust that takes everything that we put into that good warranty deed to trustee and we spell it out in that memorandum and we record it right after we record the deed. Now, let me stop right here because I'm getting a lot of blank looks. Is there anybody that's completely, totally lost? Okay, there's a couple of you that are completely, totally lost. We're talking about putting a property into a trust as part of using trust for creative real estate deals. Okay? So title goes into the name of the trustee via a warranty deed or limited warranty deed to trustee. Somewhere on public record, we have to spell out What are the rights, duties, powers, and authority of the trustee? Because remember, the trustee has control over the property. The trustee could be an entity, could be a person. But the trustee, according to the terms of the trust agreement, has to do what they're told to do. So we want to be clear about what they're allowed to do. So we put it in the deed and we put it in a memorandum of trust, and these get recorded on public record. So please, please, please do not be like some of the slim shady investors I've seen out there that, oh, I've got the deed, I just haven't recorded it. Do you need me to do that again? Only has to blow up once, and you look like Wile E. Coyote, you know, with the Acme bomb going off in your face. You'll learn, okay? It's much better to learn from somebody else's mistakes than your own. All right. So, the title holding trust agreement. Somebody's be like, well, Jeff, that sounds complicated. It's really not. Now you're going to say, well, Jeff, why do you keep using all these big words? Why do you call it a grantor revocable title holding trust? Why don't you just call it a land trust like everybody else? And I'm going to just flat out tell you, I don't like that other term, the LT term. I don't like it. Because it's been plagiarized, bastardized, diluted, pasteurized, Mohammedanized, you name it, it's been destroyed by a bunch of well-meaning, poorly educated, slightly slippery gurus. I'll never forget listening to one of them go, oh, I just put the property in trust. I'll worry about creating the trust agreement later on. I went, dear Lord in heaven, please forgive that guy. All right. Because the first thing you create is the trust agreement. The first thing you create is the trust agreement. The second thing you do is the deed to the trust. Okay? So I call it a grantor revocable title holding trust because I'm much more specific and because I want to get away from that bad term out there. Grantor revocable means that the person who created it can change it. Is that good? For control freaks, we love it. We can change our mind. Ladies, you're allowed to change your mind legally. Okay? Grantor revocable. Title holding trust. Title holding. Hey, it's here to hold title. We're going to hold title in the trust, and as a trustee, I'm holding title for the benefit for somebody else. But you don't get to know who that is. That's a secret. That's private. That's confidential. You don't get to be told that. See, if I bought a house from Al, and Al deeds it to Jeff Watson, everybody knows Jeff Watson owns the house. But if Al deeds the house over to Wendy Sweet as trustee of the 314 Grantor Revocable Title Holding Trust, no one knows who the beneficiary is. And if they don't know who you are, they can't send you a bunch of spam. They can't text you. They can't call you. They can't annoy you. They can't sue you. It's a lot harder to find and sue a non-existent, missing, hiding person. It's a lot harder. I mean, you're not going to get a phone call for your car's extended warranty, okay? All right. Sometimes I'm not sure if you guys get my humor. Sometimes I think I'm way over the edge. But anyhow, all right, so here's some language that we have in here, okay? And folks, it's really simple. I know these documents seem to be overwhelming, but there's just a few simple things. You need to know the name of the trust. You need to know the date you're creating the trust. You need to know the address of the property, and you need to know who's going to be the trustee. Because it's going to be one of your beneficiaries, one of your entities is going to be the beneficiaries. It's pretty simple, okay? And you go, yeah, Jeff, that's easy for you to say because you've only been doing this for 32 years as a lawyer. Okay, well, I'm trying to get the cookies down where 8-year-olds can get it, okay? Maybe I'm not succeeding yet. We'll try. We'll keep working at it. All right. So the trust agreement, here's some language out of one of my favorite trust agreements, and you'll notice this, that the grantor and the trustee are about to cause to be conveyed an interest in real estate to the trustee. Specifically the property described in the attached Exhibit A, which said contract and such property interest shall be held by the trustee in trust as he, she, it agrees to hold it, and the proceeds, profits, avails thereof, if any, which may come into the trustee's possession for the uses and purposes hereunder set forth shall be referred to as the trust property. What did all that say? It says we're putting a piece of property into the trust. It may be the contract to buy the property gets put into the trust and then the trustee closes. I like that strategy a lot. Assign the contract to buy out of your name into the name of the trustee to buy, and then so title is vested automatically in the name of the trustee. I love that strategy. So now here's the part where we should all be happy. Everybody should celebrate. We should all be like, in fact, let's do this. I want to create a little bit of FOMO. How many of you know what FOMO is? Fear of missing out. So how many of you would like to be the guy doing the dirty job? How many of you want to be the Gen Z getting the Uber Eats delivered? Okay, if you want to be the Gen Z Uber Eats, get all the benefits, not have to do the work, then can you just join me in a round of applause? All right, we're trying to create just a little bit of FOMO to see if anybody walks in to see what we're doing now. All right? Because we want the benefits. To quote Cuba Gooding Jr., show me the money. Okay? Show me the money. That's the beneficiary. All right? They get to just enjoy the benefits. Now, that may mean that they have to actually do one of two things. They may have to go to the mailbox, open it up, pull out the envelope, open up the envelope, look at it. That's a check. I got to go deposit the check. Oh, wait, I got mobile deposit. Let me turn it over, sign it, take a picture, mobile deposit. Okay. I thought I'd have to talk to somebody. Okay, I don't have to. All right? Is that okay? We all good with that? All right. So that's what the beneficiary does. Now, so the persons named in the attached Exhibit B, as it may be amended from time to time, are the beneficiaries. And as such, shall be entitled, there's that word, progressives love, okay? Entitled by contract to the use, enjoyment, occupancy, earnings, avails, economic benefits, and proceeds of the trust property according to their respective interests set opposite their respective names under the circumstances shown in Exhibit B. Individually and not as partners or of a partnership unless a separate written partnership is entered into. Now that's a little bit of language I tossed in there after time because I didn't want anybody to think that two beneficiaries were actually a partnership. Okay, just trying to resolve any potential tax issue that's there, okay? So that's the beneficiary. They get to just sit back, relax, and enjoy the scenery, cash a few checks. All right. So here's some more of the beneficiary interests. I'm not going to read this all to you because you're all going to get a PDF of the slides, okay? But they get the right to direct the management, use, and occupancy of the trust property and the right to enjoy and control the property as set forth in Exhibit B, which means if you own 100% of the trust or if your LLC owns 100% of the trust and you control your LLC, well, the LLC gets all the benefits. They get all the money. Everybody's happy, okay? Oh, now we get to this part. And if there's an area where I have watched more investors screw up, aside from the way they formed the trust, this is the area. Oh, I'm going to just assign the beneficial interest of the trust over to this person, and that's how we're going to transfer title of the house. There's a right way and a wrong way to do that. So that's why you see where I say seek legal advice before doing this. Now, as I was standing in the airport on the way here yesterday, I'm on the phone with the dad of a seller negotiating exactly how we're going to be doing this on 3 houses that his daughter is selling to me. Okay? I'm buying the beneficial interests of the trust, all 3 trusts, because I want to leave that undisturbed. What do you mean? I want the houses to remain in those trusts. So I'm buying the beneficial interests of the trusts. Then I'm going to change the trustee. And oh, by the way, I'm also taking the debt subject too. Oh, and by the way, I'm doing an installment sale to the seller on their equity. Leon, I think I did everything right. Is there anything I left out? Sounds pretty good. I'm buying the trust, seller financing the down payment and the equity, and I'm taking all the debt subject to. I think that's pretty cool, okay? I think, but you got to know what you're doing, okay? But you can do that kind of creative stuff if you learn these things, okay? So I'm going to be like, okay, if I was back up in Milwaukee, you guys would really appreciate this joke. It's like, we're going to teach you the basics. I'm trying to cover basics today. This is a primer on trusts. So you can be like Vince Lombardi someday and go to the world champion Green Bay Packers, gentlemen, this is a football. Okay? Real estate investors, this is a trust agreement. This is what we use as a tool to make money and do it quietly and privately. Everybody good with that? Okay. Now, we're going to talk about the trustee, duties and power, the trustee decisions. The trustee has a massive amount of authority when so instructed by the beneficiary. When instructed by the beneficiary. So if the beneficiary says sell the house, the trustee sells the house. If the beneficiary says rent the house, the trustee rents the house. If the beneficiary says maintain the house, put a new roof on it, the trustee makes sure a new roof gets put on it. If the trustee says make sure that the gardens are planted and the roses are watered and all that stuff's got to get done. The beneficiary can't go do it. The trustee has to do it. Who opens up the bank account? Who handles the money? The trustee does. It gets then paid to the beneficiary, okay? We do this in a way, and please, please, please understand this. We're using this tool for anonymity, which is also privacy, and an element of asset protection. How many of you would like to just do everything fully exposed? Everybody knows what you got, what you're doing, and who you're doing it with. How many of you would like to be a little more private and discreet? Okay. So if you want to do private and discreet, this is an element of doing it. Because guess what? I've got some great news and I got some bad news. Which do you want first? The bad news is the Corporate Transparency Act, which becomes effective at the end of this year, means that anybody who owns 25% or more of any kind of entity, LLC, corporation, partnership, whatever, they've got to disclose that to FinCEN, Big Brother, Skynet, okay? That is not the case for a trust. So everybody can know who owns the LLC, or the government can know who owns the LLC, but no one knows who owns the trust. A little bit of room there, a little bit of room there. Not much, but a little, okay? Don't worry, they'll fix that. They'll fix that. Don't worry. Government's here to take care of us, okay? We're just fine. Just trust them, okay? I know. Some of you are like, Jeff, either your humor is really bad or you're schizophrenic. Which is it? Or a little of both. All right. So, powers and duties of the trustee. While the trustee is the sole title holder of the real estate or the real estate purchase instruments held by him or it hereunder, so far as the public is concerned and has full power to deal with it, it is understood and agreed by the persons in interest hereunder and by any persons who may hereafter become interested, that's referring to the beneficiaries, by the way, that the trustee will deal with it only when authorized to do so in writing, and that he, she, it will, on the written direction of all of the beneficiaries hereunder, at the time, make contracts or deeds for the sale of or otherwise deal with said real estate or any part thereof. What did we just say there? Bunch of words. The beneficiary tells the trustee what to do. In writing. I got a whole slide on that. Okay? In writing. So, unless so directed by all the beneficiaries holding the power of direction, the trustee has no power to control or influence the real property or any use of it. The trustee has the power to purchase it, sell it, when told to do so. Written instructions. Here's that slide, Leon. Written instructions. That does not mean a phone call. That does not mean a telepathic message. That does not mean, I meant to say this, but I didn't. No, it means an email, I like emails. A saved text message, you notice I have a question mark there. Not a big fan. Screenshot it, save it, whatever. Formal direction, especially on big dollars. Yes, I want to do a special formal written direction to trustee when I'm telling them to sell the property or when I'm telling them to do something else. Okay? And all deals are titled in the name of the trustee, of the trust and the trustee, such as title would be vested in the name of the Note Squirrel Trust, G Maverick as trustee. Okay? Now, why am I doing it that way? Can I go down into the weeds with some little technical mumbo jumbo for a second? Would you all put up with me doing that? So we all know now that a lot of data regarding real estate is entered online, correct? And it's available to be found online. And we know that county recorders and county auditors' websites, they enter down who is the owner of the property. We also know that the fields in their data entry screens are only so big. So I want to feed them with data that fills up the field without fully giving up the name of my trustee. I'd rather them know the name of the trust without fully getting the name of my trustee. So I always will set it up to where the name of the trust comes first, and then I'll follow it with comma, blank as trustee and not personally. Just trying to play the game a little bit, just a little cutting edge twist, that's it. All right? Now, here's the part where y'all are going to get cheap on me until you think about it. Okay? The trustee needs to be compensated. Okay? Well, how much should I get paid, says the trustee. And the beneficiary goes, zip, zilch, nada. I don't want to give you anything. More money for me. Wait a second. But wait, I'm also the trustee, even though I've got a separate beneficiary. So it's okay for me to take money from my right pocket and put it in my left pocket. Not only is it okay, but it's actually very prudent and probably necessary. Let me explain. If you're not adequately compensating the trustee for the work that they actually do, right, Bill? For the work that they actually do, then you could be subject to the argument of it's really not a valid trust. They're not doing what they're supposed to do because trustees get paid to do this. If the guy is not getting paid, then it's not really a deal. So we want to get the man paid for what he actually does. So in your trust agreement, I spell out what you should be paying on an hourly rate. Okay? Now, do you have to pay my hourly rate? No. But it's got to be, can't be chump change, can't be minimum wage. Okay? So, we want there to be actual compensation paid to the trustee on an annual basis. So, we X out the zip, zilch, and nada, and we bring it over here. Now, the way I draft a trust agreement, the first year, the trustee's compensation is $500. I figured they've got about 5 hours in at $100 an hour. Okay? Or I could make them work really hard for half that price and make them work for 10 hours at $50 an hour. Whichever way, I don't care. Succeeding years, I set it kind of at $300 on an annual basis. It's not a lot of money, but it's a legitimate amount of money to say, hey, listen, they spent 3 hours at $100 an hour, boom, they get $300. All right? So what are you really doing? Well, if you get important information, you need to pass it on to the beneficiaries. All right. But the trustee has the right to go, I quit. And I've had trustees do that. And I think that's great. Okay? So the trustee may resign at any time by mailing a notice of his or her intention to do so to each of the beneficiaries at their last known address. Trustees are allowed to quit. And so then you have to have a replacement or successor trustee. But did you also know that you can fire your trustee? You can say, hey, we're replacing you. You can do a Donald Trump on him. You're fired. Okay? No mean tweets. No mean tweets. Okay? We're a much better country now because we don't have any mean tweets, even though we've got inflation through the roof. Okay? All right. So, trustee can resign. When the trustee does resign, either they're fired or they resign, they need to convey the property to the successor trustee. This is what we're in the process of doing right now on these 3 houses I'm buying, is I've now, hint, hint, gotten my trustee to agree to take over, looking over at one of my trustees, and we're now going to convey through a limited warranty deed to the successor trustee from the original trustee, okay? Because I want the trustee that I picked, since I now own the beneficial interest, all right? So, by the way, that deal I'm doing, yes, it is a taxable event, okay? It is a taxable event, so don't think I'm just trying to cheat the system. I'm going to have to pay taxes there. All right, so trustees can resign because of embarrassment. You know, if I was the trustee of somebody else's trust and they got into trouble, I would resign. I had to resign as the statutory agent for a former client's LLC when I realized that she lied at a closing and didn't disclose a $50,000 mortgage that should have been paid off. And if you're going to lie over 50 grand, I don't want to have anything to do with you anymore. So I resigned. Okay, same thing here. All right, litigation may arise. The trustee may not have the nerves for litigation. Then there's people like me that are like, oh, lawsuit? Hey, bring it. Let me talk. Let's go. Okay? Insecurity. They may, oh, I'm uncomfortable. Liability. Oh, I don't want to do that. You're doing something crazy with that property. I don't want anything to do with that. Or there could be a hazard, such as you're not taking care of your property. I keep asking you, I keep telling the beneficiaries, we need money to fix this up. The roof is leaking. The tenants are complaining about it, Mr. Beneficiary, and you won't do anything with it. Well, hey, I'm out. I quit. Bye. Okay? I don't want to get sued. All right, that's all cool. So we can replace the trustee. Beneficiaries may at any time replace the trustee by lodging with him an instrument naming a successor trustee, signed by all beneficiaries and accepted by the successor trustee. So when I'm creating a trust agreement for my clients, or if you've bought one of my courses that has a trust agreement in it, you'll notice that I always want you to include a first and a second successor trustee. Why? Life happens. How many of you know somebody who was in great health one day and then not the next? Yep. So we don't want to get tied up to where we don't have a plan A and a plan B and a plan C. All right? We want to have a first and a second successor trustee. All right. So now we're going to get into some more technical stuff about trusts, stuff that people don't talk about that often, but I do. With a trust, we have now changed the way the asset is owned, held, and categorized. All right? This trust shall not be recorded except as required by law. The trustee needs a complete copy of the trust. Each beneficiary needs a complete copy of the trust. The grantor obviously needs a complete copy of the trust, and a title company that is going to be transferring the property, either into or out of, and handling an escrow and moving money with that. They're entitled to a complete copy of the trust agreement, and nobody else, absent a court order. And nobody else absent a court order. Okay, then we can include languages here. The trustee shall not release information regarding this trust except as required by law. In making a disclosure required by law, the trustee shall supply beneficiaries with copies of any reports filed and shall be subject to no liability for filing such reports. The trustee shall not be liable for inadvertent disclosure of the identity of any beneficiary. So we're trying to keep things quiet, trying to keep it secret. But here's one thing I want you to understand. That privacy is only as good as you keep your lips closed. If you walk around telling a dozen people that you're the beneficiary of such and such a trust, you've just defeated a lot of it. Okay? You've just defeated it. But I want you to understand, this is the part, this is the critical moment in this presentation. And you're like, okay, Jeff, you've taken 49 minutes to get here. The reason we like trusts is because of the privacy foundation that gives us in our entire asset protection structure. We like trusts because of the flexibility it gives us in our deal structuring. We like trusts because of the creativity that we can put in there as to how the beneficiaries receive what part of the beneficial interest. We like all those things. But what you have to understand is this. On public record, it says that G. Maverick is the trustee of the property for this house. But there's nowhere that it says that Bravo Holding Company is connected to G. Maverick. So Bravo Holding Company is the beneficiary of the trust, and it's never anywhere connected on public record. That's your privacy element. The only place the two are linked up is in the actual trust agreement, and that's it. Okay? Now, Jeff, this all sounds wonderful, but what if I become a beneficiary of a trust and I don't like my other beneficiaries? What can I do about it? Well, there's a few things you can do, but there's one thing that you cannot do. You can't act like you own the property. You can't go sue for the remedy of partition, asking a court to order the sale of the property and the division of it. You can't do that. Instead, you've got to solve it by what's written in the trust agreement. Okay? By the way, this trust can be amended until terminated. So that means the grantor can change the trust. Who's the grantor? You are. You've got the right. You've got control. Okay? Now, let me see if we can make this happen. All right, there we go. It moved. Termination. The trust may terminate at any time by a majority of the initial beneficiaries so long as the beneficiaries consent in writing. And then we've got a bunch of 20-year language because we're scared to death of the rule against perpetuities, yes, because we don't know how to draft around it because we weren't paying attention in class. Thank you, Mary. Yes. It's actually, there's easy ways to draft around it, so I don't know why people put 20 years in here. All right. Make sure this thing clicks one more time. Then we're going to show you some simple pages here, and we're going to move on because we got to hurry up. That's what a trust agreement looks like, is where it gets signed. You sign, your signatures get notarized. The grantor is going to sign, the trustee is going to sign, the beneficiary is going to sign. We want notarization. Well, why do we want notarization? Because if we're doing a deal involving real estate, we want to use what Dykes-Boddiford talks about as the equal dignities rule. We want to sign the trust instruments with the same formalities as we would have to do a deed or a mortgage or a deed of trust. So it means we need the same number of witnesses, we need it notarized, and so on. We got to just dot our I's, cross our T's, do it the right way. So we have to have the grantor sign, we have to have the trustee sign, and we have to have the beneficiary sign. All they have their own separate signature pages and so on with notarization. And then, because I'm down to 8 minutes and 8 seconds, we're going to hustle. We're going to have then Exhibit A to the trust is going to give the legal description of the property. How many of you know that properties transfer by legal description, not by address? Okay, legal description. So we put the legal description in there, and just to make it easier, we also include the parcel ID or the tax ID number or whatever system you use in your particular county. And then we come over here, and Exhibit B has the beneficiaries in their interest. And you notice I set this up to where it's going to be one entity that owns 100%. And then the person who controls that entity really controls the trust through 2 layers. They control the entity, which tells the trustee what to do. All right? Now, let me jump over here, see if we can make this thing do this. So let's remember our roles. There we go. Okay, we're just going to hit one more button. All right. Don't forget the role identities. You're the investor, right? Okay. Did I put everybody to sleep? You're the investor, right? Yes. Okay. You can be the grantor. You can be the trustee. And you can control the beneficiary as long as the beneficiary is a separate legal entity. Does that give you enough control freaks? Any of you FOMO people think you're missing anything? I hope not. All right. Good. All right. So now we're going to wrap this thing up with one more document. And this is the third thing I talked about, the third most important document. It's the memorandum or affidavit or declaration of trust. This needs to be recorded pursuant to state statute. It spells out the rights, duties, powers, and authority of the trustee on public record so that it can be relied upon by other people dealing with the trustee and handling title, such as a title company, insurance company, etc. Okay? And it's a memorandum of trust. It's a real simple 1.5, 2-page document. Now I'm going to jump into the risk, and then we're going to get there. Okay. Liability protections. Is there a liability shield? Not really. Statutory? No. Common law? No. Asset segregation? Yes, we can use trust to do asset segregation. This is something I could take an hour to talk about, but I don't have that time. I don't want to be rude and go over my time. Asset segregation, does it give us privacy? Yes, it does. It depends on how well you do it. Does it give us tax planning flexibility? Absolutely, and this is huge, and John Heyer and I have schemed about doing this in the past. Did I say schemed? I'm sorry. John Heyer and I have discussed how to do this. So it rolls around, it's now March 15th, and you're like, oh, I bought that house, and I was going to run it as a rental, but now I've got this amazing offer to sell it, and I've owned this house for like 9 months. I can just move it out of my buy and hold on my books over to my sub-S entity and sell it out of there, and so all the profits flow into my sub-S entity, and that entity, if it gets tagged as a dealer, so what? Because it doesn't affect my rentals, so we can use some asset segregation stuff here. Oh yeah, tax planning, flexibility, and asset segregation. This is another reason why I like trust in addition to privacy. Yeah, okay? So then here's the limited warranty deed to trustee, more language of it, and then the close. Yes, with 4 minutes and 30 seconds left, he's going to the close. Folks, that QR code. Here's what you get when you scan on that QR code. You get a combined gift. Jim and I collaborated with my friend Eddie Speed, my client Eddie Speed, to give you guys something. And this is how I'll know who wants the PDFs of my PowerPoint. Okay? Who wants the PDFs? This is how you're going to get it, okay? Now, Adam, I cut you off, and we've got just under 4 minutes. You had a question. Let's see how quickly we can do it so we can get another one in.
You kept emphasizing the need for a multi-member LLC.
Yes. I like multi-member LLCs because they give you better asset protection, and they're clearly a second person involved with that LLC is also a beneficiary or a layered down beneficiary of the trust, so I can further prove that it's just not me, myself, and I. That's why I kept emphasizing that. Particularly if you get into the state of Florida, single member LLCs are essentially worthless for asset protection. Multiple member LLCs are golden for asset protection. One trust, one house per trust, because I can create trust after trust after trust after trust. I can have multiple trusts owned by the same LLC, but I want to have one house, one trust. One house, one trust. House number 3, trust number 3. House number 4, trust number 4. Great, good, great question. Quick, anybody else? Anybody else? Overwhelming. All right. Yes, sir, in the back with the hat.
So when I'm working with a high net worth client, and they mentioned it to be a grantor revocable trust, does it make sense to do it irrevocably for those with a 25 million up asset base, or is that too complicated to change out of there?
If they're doing it for estate planning purposes, it's a completely different conversation that we're having here today. If we're talking about how to hold assets for investment purposes and appreciation and cash flow, we'll still use a revocable trust. If they're going somewhere else for either these domestic asset protection trusts or estate planning, they can think about irrevocable. That's way beyond the scope of this conversation. And then there was, yes, sir. Yes. How else are we going to put that out there on public record? Yes. Yes, sir. What about it? It's there. They may. They may. They've got the right. But they don't, not the obligation, not the authority. And as the former vice president of servicing at one of the too big to fails, looked at me one day and he says, Jeff, as long as the payments are made, we don't care. I asked the partner that ran the largest foreclosure law firm in the state of Ohio, and I said, how many houses did you foreclose on because of the due on sale clause? He said, none. I said, wait a second, you've done tens of thousands of foreclosures in Ohio, and you've never done a single one over the due on? He said, nope, they don't care. As long as the payment's made and don't ruin the house, they don't care. Now, you go rub their nose in it, you go strut around on TikTok or YouTube and you go, look what I just did. Who knows what's coming? Who knows what's coming, okay? I like to make money the old-fashioned way, quietly. All right? Yes, ma'am.
Single member LLC not safe. Let's say you don't want to go the multiple member route. What are the alternatives to still do it by yourself?
I missed the first half of your question.
Single member LLC said it's not safe, but let's say you don't want to go the multiple member route. What is the alternatives to still be able to do this by yourself?
If I refuse to do anybody else in my LLC because I have no parents and no kids and no spouse and no partner and no friends and nobody else that I like because I'm a Gen Z and I live in my own little closet and I don't want to talk to anybody, I would then go with a single member LLC electing sub S tax status, and I'd flip everything I got within a year or less. But if you want to hold it, then you got to bring in somebody else's trustee so that you remain the beneficiary. Okay, that's your other solution. And I am out of time, Mr. Ingersoll.
Oh my goodness.
And I want to be respectful.
Woo!